All right, welcome. We are in chapter 5 now of our text, and this is again for the Wake Tech Court Procedure and Evidence class being offered in the spring of 2023. I'm James Chapman, your instructor. The text we're using is the 10th edition of Criminal Procedure by Joel Shamera, and we're going to be looking at chapter 5 today, which is primarily arrest. There's a few little caveats or a few little small things thrown in. But good morning, and we will jump in here and start talking about arrests. And one of the things, because we're just coming out of stops under the Terry stop, is that a seizure is deemed to be more intrusive, more serious. So to stop you, to articulate a suspicion, for example, we're going to look at the kind of pyramid of evidence that we need for these things, is really the beginning. The arrest is a intermediate stage, and of course conviction ultimately is the highest stage in the criminal justice. Okay, so to move along here, these are Fourth Amendment seizures. So again, when we're doing our analysis of this, we're going to be looking at primarily Supreme Court cases. We're not going to look at a lot of statutory, although statutory authority to make arrests can be important. We're not going to look about a lot of evidentiary rules because it typically doesn't come up except in application to what the arrest is. Sip my coffee there. So they require a higher objective basis to make them reasonable. Remember, all searches and seizures, because arrests are seizures, have to be reasonable according to the Fourth Amendment. So they are a little bit different than stops in a couple of ways. And your book focuses on these three: duration, location, and record. So the stops are typically measured in minutes. So if you're talking about a Terry stop, ideally, I guess you could say a Terry stop is a very short period of time. It's 5 minutes to stop someone, pat them down, give them a couple quick questions. The other difference is the location. Again, stops typically take place in public at the same location. On the other hand, arrests, because you're bringing someone into custody and you're going to be confining them, by their very nature, usually entail an asportation. That's ASPORTATION. That's to move someone, sometimes against their will, from one location to another. So we have an asportation. We are taking the individual from where we're finding him and we're bringing him to a different location. And of course, there's more of a written record because the arrest produces a document, an intake document, all sorts of pieces of paper. And if you work in a bureaucracy, one of the things you're going to realize is that they function based on paper. So there's going to be written documents that become part of a permanent record that is attached to this person. There's no record of John Smith being stopped and frisked necessarily. There could be, but there's certainly going to be a record of John Smith if he gets arrested. So let's talk about, I mentioned briefly when we were doing the introduction, the amount of evidence we need. And last chapter, if you recall, in chapter 4, we had that kind of steps. Well, one of the ways in which we learn is we are presented with information in a repetitive way, but also with enough change that we learn it again. And the way you're going to learn it again here is, as opposed to steps, I'm going to show you a pyramid. So this is the amount of evidence that you need, starting really from an investigation of a crime. Do we even know that a crime occurred? You need any evidence whatsoever. If you have no evidence that a crime occurred, and you see an individual walking the street, and you're a police officer, you have no more right to stop him than I do as a citizen. So then we go to reasonable suspicion. Reasonable suspicion is enough really for that kind of stop and frisk in the shorthand. Then we go to probable cause, which is really enough to arrest someone, to bring them into custody, really begin the formal process of adjudication, which is basically trial. Now, these other standards, preponderance of the evidence, clear and convincing, reasonable doubt, these are all standards that are used in court by and large to establish a level of either liability which is usually what's the term used in civil cases, in which case we use a preponderance of the evidence, or criminal guilt, in which we use the term reasonable doubt or beyond a reasonable doubt, which is the highest standard. Now, the two in between, clear and convincing and reasonable doubt, clear and convincing evidence is used in a couple situations. It can be used sometimes in commitment hearings. It can be used in certain type of fraud liability, in which we want a higher standard than mere preponderance of the evidence, the sort of 51 to 49%, but we don't need proof beyond a reasonable doubt. So the next thing is to talk about an arrest. The thing to remember about an arrest is it's not over and done. It's not a point, but rather it is a spectrum, a number of things that happen. The Fourth Amendment of the Constitution of the United States requires that arrests be supported by probable cause. The police or a government official, FBI, for example, DEA, can't bring you into custody, can't arrest you unless there's probable cause. Now, that probable cause can be reflected in an arrest warrant, or it can be, he saw you commit a crime in his presence or has a reasonable belief. But we're going to have a custodial arrest, and we're going to officially take someone into custody, and they are going to have to answer to a criminal charge. They're going to be charged with a crime, and we've got to charge them with a crime in almost all cases. Now, there's going to be a few kind of on the edges here that are pretty rare, that could be a little different, but custodial arrests require us to say, here's what we're charging John Smith with. We're going to show a neutral judicial magistrate that there is enough basis to go to trial. All right, now there are different characteristics of what goes on in this arrest. So here are some of the things that can happen. First of all, you can be notified you're under arrest. That is, you are aware. Now you might say, well, of course people are aware, but there's going to be circumstances where an individual has passed out. Let's suppose, now North Carolina has a statute, when we talk about public intoxication, North Carolina statute is called drunk and disruptive. It is not illegal per se, just a fancy legal term for meeting automatically. It is not automatic that if you're drunk in public, you can be arrested. North Carolina requires you to do something else, and in conjunction with being inebriated or intoxicated or high. And those things generally are fighting, boisterous language, blocking an entrance or an exit. But you might have someone that got drunk and passed out and is blocking an exit now. Well, that person is subject to arrest, but it's not going to do any good if the police officer comes up to a drunk that's passed out and says, you're under arrest. Yes, 99% of the time you're going to be notified you're under arrest. Next thing that frequently happens, you're put in a squad car. Now sometimes, again, let's take someone who's inebriated, you might call an ambulance. If you see someone that is intoxicated to a dangerous degree, the jail probably won't admit him. The jail will say, take him to the hospital. And this is going to vary depending on your big town, small town, where you are. But usually, you're under arrest. The next step, we put you in a squad car, and then we take you to a processing facility. Now, the shorthand I used is you're taken to a police station. Now, sometimes what happens, of course, is you're going to be taken to a jail, which, you don't have to go to the police station first. It depends upon a lot of factors. The suspect is photographed, booked, and fingerprinted. Now, this is an interesting stage in that it's kind of an intermediate stage. It's kind of a stage where we're creating more of a record for the process than we are seeking evidence about the crime. Although some of this stuff obviously is available for use in court. So a photograph of someone, let's suppose that you have a suspect that is accused of being committing a fray in North Carolina, which is basically fighting. You might take a photograph of his hands, or his fists, or his face if it's lacerated. Obviously, fingerprinting can be extremely useful. You don't have fingerprints in a system automatically. We don't do that in the United States, where when you're born, we take your fingerprints and we keep them. Generally, you wind up in the system if you are have been arrested and convicted of crime, usually, sometimes just arrested, or there's some other reason, like you applied for a governmental job that required it. And you're going to be booked. This begins the formal paperwork. Again, I said that the paperwork is important. The suspect is searched. Now, this can be important. Obviously, what you don't want is you don't want contraband coming into the jail. So part of the arrest, part of the custodial arrest, is a search. Remember, there's the search and seizure. So if I search you and the arrest was bad, if they had no right to arrest you, then the search that is subsequent to the arrest, any evidence that produces inadmissible. At this point, the suspect is placed either in a police station, usually a holding cell, something like that it can be called, or they might be taken to a county facility in North Carolina, a jail. Very often, at this point too, they might be released. They might have a magistrate release them on their own cognizance, ROR as it's called, or they might be released on bail. It is possible at this point, and we're going to look at things like Mirandizing people, that the suspect will then be questioned, will be interrogated. It doesn't happen all the time. It doesn't necessarily have to happen at all, but it certainly may happen. Just like the next step, we may have a witness, and we might want that witness to view the suspect to confirm, yes, indeed, this is the person that stole my purse, that raped me, that shot the individual, all of those. All right. Now, if we look at deprivation of liberty, we look at this kind of scope here, from stops to imprisonment. Okay, so what do we need? Well, if you're having voluntary contact, if the police officer is just walking and he sees someone, he can ask him questions. He doesn't need any evidence. He doesn't have any special rights. You don't have to answer those. If a cop comes up to you and says, hey, I got a couple questions for you, and you say, am I being accused of a crime? And the cop says, no. Am I a witness to a crime? The cop says, I don't know. I want to ask you some questions. He's got no more right to ask you a question at that point than a TV reporter coming up to you. So usually a voluntary contact, very brief, very much on the spot. The degree of the invasion here is the psychological pressure, the moral pressure to answer questions. Most people have a desire to cooperate. Now the stop, and this is shorthand to Terry stop, remember you have to have that reasonable or articulable suspicion. Should be very brief. Should happen in that location. And what you're going to be looking for is you're going to be looking for identification. What's your name? Why are you here? The arrest, of course, you're going to need probable cause, and the arrest is going to last for hours or days, and we're going to take you to the police station. Then we go through that kind of paperwork procedure, the fingerprinting, the booking, the photographs, the interrogation, the identification procedures. The actual detention, and this is usually pending trial, and this again doesn't happen to everybody long term. This can be months to days. This is where someone's held in jail pending the trial. You're going to have an inventory. You're going to have a body search. You're going to have a strip search. You're going to have body cavity searches possibly. And you're going to have restricted contact with the outsiders. This is going to be in jail. Jail is different than prison. Jail is where we hold people typically pending trial, or if they've committed very minor crimes, misdemeanors usually. Prison, on the other hand, someone has been objectively shown to have committed a crime beyond a reasonable doubt. So here there's less rights of privacy, liberty, and property. There's far more right to restrict people. So let's go to this very important concept, that kind of fourth one there on the list, I guess, probable cause. Let's talk about that. Probable cause to arrest. Now, by itself, probable cause is not the only element of a reasonable Fourth Amendment seizure. There's also the way in which you arrest someone, the manner of it. So you might have probable cause to make an arrest, but the way in which you make the arrest can be very important. Suppose, for example, we take a fictitious situation where police officers, when they arrested men, always handcuffed all the men, no matter how old they were or how young they were, from ages 5 to ages 95, they always handcuffed them. And for women, they didn't handcuff them. Well, you might say that even if they have probable cause, the arrest is being conducted differently. Now, project that to something even potentially uglier. If they only handcuffed Latinos, if they only handcuffed, make up a group. I tend to use a fictitious group, albino, Chinese midgets. That just a group you're never going to see, but you can talk about it and say, well, if that group was treated that way, is the way in which the arrest occurred would interfere with your Fourth Amendment rights about seizure. Now, one of the big ways that we see this, besides the way, is where. So remember, we talked about expectation of privacy in the last few chapters, and one of the things that we said was that there is less expectation of privacy the further you get out of your house. Your highest expectation of privacy, your highest protection, is when you are in your home, doors shut, windows shades down. You are basically the man in this castle. At that point, if the police are going to arrest you, they better have a warrant. It better not be a warrantless arrest. Hey, Fred's in his house. Fred robbed the bank. I'm going to go arrest him. Well, what you should do properly as a police officer is go to a magistrate, say, I have evidence that Fred robbed the bank. The magistrate will hear your evidence. You will sign, swear, oath or affirmation. You have a piece of paper issued. You now have an arrest warrant. That arrest warrant is good enough if you go to the house to arrest Fred in his house. But if you just hear, hey, Fred committed a crime, I'm pretty sure he did it. Fred was a pickpocket, I'm pretty sure he did it. I'm going to go to his house and arrest him. You can knock on the door, but if Fred don't come to the door, you're not going in. Also, officers can only use reasonable force to maintain control over arrestees. If a police officer had to kill someone to bring him into custody, you certainly wouldn't want that police officer killing someone who committed a very minor crime. Hey, you're jaywalking, and the guy starts to run, and you take out your gun and you shoot him, because that's a seizure. You would say that officer might have had probable cause. He saw the guy committing jaywalking, but the manner of the arrest, the manner of the seizure, the deadly force used was improper. Okay, so there are two elements in a reasonable arrest. Do you have the probable cause, and is the way you did it reasonable? And probable cause is required for all arrests. Now, probable cause can exist either beforehand, where you go and get a physical warrant, or sometimes it can exist simply, objectively or in the mind of the officer. Now, applying this standard, probable cause rests with the officers on the street. They very often have to make quick decisions. Now, for a lot of crimes, no, they don't need a warrant. They don't have to go to a judge and say, I've got probable cause. If you're on the street and you see someone sell someone else a dime bag of drugs, or you see someone hit someone else, you don't need to go to a magistrate and say, hey, I saw John hit Mary. We're going to say that your expertise lets you know that that constitutes in North Carolina assault on a female or assault inflicting serious injury. Now, obviously, if you go to a judge and you say, I think I've got probable cause, and the judge looks at it and says, no, you don't, then you're done. You don't have probable cause. Judges have the final say. However, it's very, very clear that courts will tend to accept the facts as the police see them. Because you're arguing ex parte. You're arguing with only one person. If I'm going to get an arrest warrant to arrest John Smith, John Smith typically is not there to say, hey, that's not true. The only evidence that's being presented is the evidence being presented by the police. So obviously courts will tend to accept those facts and the way those facts are colored by what the police say. Now, probable cause to arrest requires that first of all, you have to believe a crime's been committed. The officer has to have, looking at the facts and circumstances, a reasonable belief that there's been a crime. Not that someone's just a bad person. Now, it's either the crime has occurred, is about to occur. Hey, I heard that John Doe is getting ready to blow up the legislature building. So, he went and bought dynamite. So he's begun this. Buying dynamite not be a crime, or he's making black powder in his basement. Well, you can make black powder, but I have a suspicion now because he posts on a bulletin board or he posts on a website or something that he's going to blow up the Brooklyn Bridge or whatever we're talking about here. So basically, you have to believe that a crime's about to happen, and importantly, the person you're arresting has committed that crime or is about to commit that crime or is in the middle of committing that crime. So not only is there a crime, but this is the guy that did it. So it's kind of a two-step process. All right, so this reasonable belief is not based upon the same analysis of evidence that we see in a court. Because after all, there's going to be evidence in a courtroom that can be excluded. One of the things that can exclude it is hearsay. Hearsay, quite simply, is when someone tells you something and you are led to believe that what they are telling you is true. Very often that they overheard something. The technical definition of hearsay is an out-of-court statement being offered to court to prove that what was said was true. What we abbreviate that is an out-of-court statement being offered for the proof of the matter asserted. Now, the classic hearsay is inadmissible in a court of law because we don't trust it. But a police officer is perfectly free to use hearsay as a basis for an arrest because it's a lower standard of proof. The probable cause requirement here balances our need for crime control with the individual's right of locomotion, the individual's right to move around and to be free. Now, the best evidence you can have is not hearsay like I just talked about, but it's going to be direct information. You see it firsthand. Why do you think Fred robbed the bank, Officer O'Malley? Well, I was standing outside the bank. I saw Fred get out of his car, put on a ski mask, take out a shotgun, walk into the bank, shoot it in the air, grab the money, run out of the bank, holding a bag of money with his shotgun still smoking. That's direct evidence. Now, that can be enough. Sometimes direct information is enough with other circumstantial evidence to show they did it. So you hear that someone that was 6'8" robbed the First National Bank. You happen to know that there is an ex-bank robber that just came to town and he's 6'8". That gives you direct information. Hey, someone very unusual matching this information, and then gives you circumstantial information. And taken together, that's kind of a weak probable cause, but that might be enough certainly to investigate. And then if you go to the guy and he has no excuse where he was, and you see him and he smells a cordite or firearm, and a gun was shot off, that's enough circumstantial evidence to bring him into custody. Now, direct information doesn't automatically make it, but the courts will look for patterns, and what they will do is they will look at all the information, what we call in the law the totality of the circumstances. And that can be used to build probable cause. Now, let's return to our friend hearsay, which I kind of gave you a little bit of a jump start on. Hearsay is secondhand information. Now, I've had students say, well, then hearsay, is not very good. Well, think about this. You have been told your whole life that your mother is your mother and your father is your father. Most of you, unless you've had a paternity test done, don't have scientific evidence, conclusive evidence, direct evidence of your paternity. You only have hearsay. You only have people that have told you that, oh yeah, that is my son. But it's pretty good, isn't it? So hearsay information is secondhand, but don't dismiss it. Hearsay is second information known to the arresting officer because they're interacting with other people. Hey, John, did you see who robbed the bank? Yes, it was Fred. That's hearsay. Now, the general rule in court, remember, hearsay is an out-of-court statement being offered with proof of matter asserted. Police officer questions John and says, John, do you know who robbed the bank? And John says, I heard that Fred robbed the bank. That's hearsay, but it's enough, at least for an arrest, potentially. The hearsay rule in court prohibits secondhand evidence like this to establish guilt, but it can be used for probable cause. Now, not all hearsay is the same. The hearsay that you get from a fellow police officer, hey, did you see what happened, Officer Bob? Yeah, I saw John rob the bank. That's different than the hearsay of, hey, I have a confidential informant who's a drug addict and is 95 years old and suffers from dementia and has bad eyesight. Hey, did you see you robbed the bank? Yes, it was Fred. Well, that hearsay has less weight. But you have to be careful with hearsay. This next little cartoon, I just put it out there. Ladies and gentlemen of the jury, we have hearsay evidence from the lady who told a friend of her hairdresser that cousin Julie. What more do we need? So, you got to be real careful. Hearsay can be the basis of arrest, but it shouldn't be conclusive evidence. It isn't conclusive evidence. Evidence can have different uses depending upon the point of time. You can have evidence when you're getting suspicious, when you're arresting someone, when you're arraigning someone, when they're at trial, when they've been convicted or appealed. So there's all different stages. All right, so let's talk about the warrant. Generally, courts much prefer warrants. Obviously, most arrests don't necessarily occur with warrants. But the nice thing about a warrant from the police officer's point of view is that he's gone to a magistrate, a neutral judicial magistrate. Now, in North Carolina, that conceivably could be almost any judge. Could be a magistrate, small claims. Could be a district court judge, could be a superior court judge. And he's gone to that judge and said, here's the evidence I have, Your Honor. I think it reaches the level of probable cause for arrest. The judge looks at it, the judge evaluates it and says, yes, it does, or no, it doesn't. Well, the decision has been made by the judge, not the police officer. If you're going to a home, and I want to say this in North Carolina in particular, if you're going into a home, you better have an arrest warrant. The courts in North Carolina are extremely suspicious of any arrest made in home without warrant. They really believe, and North Carolina law reflects this, not just the courts. We have something in North Carolina called the Castle Doctrine, which allows you to use deadly force in certain circumstances in your home that you would not have the right to use in public. We really believe that your home is safe, sanctity. So what are the requirements to get one of these warrants? Well, the Fourth Amendment requires three elements. One, you got to have a neutral magistrate. We could have looked, or your book could have provided, there's some old case law where people, I think it was a Vermont case if I'm not mistaken, applied for a warrant through the Attorney General. Well, the Attorney General is a prosecutor. He's not neutral. Of course he's going to support the police. So they're not neutral. You have to have a disinterested judge decide, is there probable cause? The next thing, remember the Fourth Amendment says oath or affirmation, is we want an affidavit, a sworn statement. That's going to be your oath. Usually what that is a police officer comes in and says, this is what I know, and then he signs a piece of paper. Now, why is that important? Well, because when he signs that piece of paper, he's making a legal representation. If he's lying, and he knows he's lying, he's committing a crime. And what should be in it? I'm going to show you a picture of a North Carolina warrant in a minute, but it should have who you're arresting, how we know what they'll look like, what's their name, very often where they are. So let me jump ahead here in the next slide. This is a North Carolina warrant for arrest. So typically, for 90+%, because you got to remember that most crimes are minor crimes, misdemeanors. This is going to be issued by a magistrate, which is sort of a judge in North Carolina, is a judge, has magisterial powers. Typically, they're issued by a magistrate or a district court judge, occasionally by a federal judge or a superior court. And these warrants will exist both for arrest and for searches. So you can see there that, I'll bring my mouse over here, you can see that it's got the defendant's name, the state of North Carolina, and under here you've got information. Okay, this is the testimony, this is the information you're going to get. And that judge is going to sign it, and he's going to give it to an officer that has jurisdiction, and that officer is going to go out and make an arrest. And if he doesn't have one of these warrants and he's going in a home, the next point we're going to look at, we got problems. Actually, the police officer has problems. Now, so probable cause is enough to make an arrest outside of a home. I saw Fred rob the bank. But if you're going into a home, you better have one of these written warrants. There's going to be a couple exceptions, but the Supreme Court says entering a home is the chief evil the Fourth Amendment was intended to protect. Now, this really goes back to a little bit of history. You have to remember that the Bill of Rights, the whole Constitution, is written right after the American Revolution, just a decade or so afterwards. And they had lived under the British, and the British, one of the things the British had done, was they had invaded the homes of Americans, weren't Americans yet, they were British citizens, and they had searched them very often. They had entered homes, sometimes with no warrants, sometimes with blank warrants, and the Fourth Amendment is really designed so this doesn't happen again. A lot of it is designed that way. So, for example, the Second Amendment, because the British tried to seize arms, the right not to be, Third Amendment, the Fifth Amendment, Eighth Amendment, all of these really are to redress things that happened to the Founding Fathers. Now, there can be exceptions, and here's one of the exceptions: exigency. Now, in a case where a man was alleged to have been in a traffic accident and driven away, officers went to his home, knocked, didn't get an answer, broke down the door, found him in bed, and arrested him. And they said, well, is this okay? And the case is Hopkins versus Bonavicino. And basically they said no. There's no reason. Now, this case could have been much different if a man had stolen a machine gun, fled, killed 47 nuns, fled to his house, ran into the house, the cops were on his heels, he got in the house, and the cops went in after him. That's an emergency. So when we say exigency, we're really talking about an emergency situation. So what are some of these situations we see? There's been a serious crime. So there's no exigent circumstances if we're talking about minor misdemeanors. Yet another reason we might enter without warrant would be a belief they're armed, and that the more time you give them, the more danger it becomes. How much evidence do you have someone did this? Is there a reasonable belief they're inside? Is there a reasonable belief that they might escape if you don't go in? And is there non-forcible entry? So one of the things we see very often is a chase. Someone commits a very serious crime, sometimes armed. Usually it's a felony, usually it's serious. They flee to their home. The police are hot on their heels. They know he's there. They have a limited amount of time to go in. If they don't go in, he could jump out a window, escape. He's a dangerous individual. That's going to give you probably enough to go in. But still, it's always better to get the warrant. All right, arrest by force. The Fourth Amendment permits officers to use an amount of force necessary to apprehend and control them. So really you can say there's two types of force: deadly force and non-deadly force. Now, deadly force doesn't mean just force that is going to kill you. Serious bodily harm is still deadly force. If you shoot someone in the leg, that's deadly force. Deadly force can be used if you've got a dangerous suspect, but of course it shouldn't put innocent people in potential danger. So let's look at the next slide here, deadly force. Traditionally, the police could use deadly force whenever they wanted. And deadly force was simply anything capable of producing harm or death. You don't need to actually kill someone, but it's got to be serious harm. By the 1960s, limits were emerging on the use of deadly force. And we have the major case, one of our first major cases here. We have Terry v. Ohio. This is probably the next major case you should be aware of. Tennessee versus Garner. It came down in 1985. We have 15-year-old Edward Garner. Now, he's in Memphis, and he's been committing a burglary. And the police are aware. There's quite a, well, the actual crime occurred in 1974, so you can see this takes 11 years to get there. He was killed by, I believe the name's officer was Heyman. He was committing a burglary, and he was fleeing the scene. Garner was trying to climb over a fence, and the police were reasonably sure that he was unarmed. In fact, one of the officers said he was unarmed. He was told to halt. He began climbing over. Heyman shot him. The bullet hit him in the back of the head. He was taken to the hospital. He dies on the operating table. They find $10 and a purse, which were taken from the house. So, yes, he was committing the burglary. What the Supreme Court says here, and I believe Justice White wrote this opinion, and there was a dissent. The dissent was written by O'Connor and was joined by Berger and Rehnquist, was that you can't use deadly force to prevent the escape of all felons. That the amount of force, okay, has to be kind of proportional to what crime we're talking about. This was a non-violent felony, okay? So that was not enough. Now the dissent said, hey, and the dissent, again, written by O'Connor and Rehnquist and Berger, said, burglars are dangerous, and he refused to stop, so it's okay to shoot him. But that's the dissent. The general rule under Tennessee v. Garner is, if you're going to kill anything that's likely to produce death or serious injury, it probably should be a violent, dangerous felon. So, what is then excessive force? The court created what they call the standard of objective reasonable force. This also applies to non-deadly interaction. Two elements. There has to be probable cause for arrest, and the amount of force used must be objectively reasonable. Well, obviously this was not going to end the analysis. And a few years later, in 1989, we have another case, Graham versus Conner. Now, this is a pretty interesting case. Graham, and this case actually occurred in North Carolina. So Graham it happened in Charlotte, if you want to know. Graham was a diabetic. So he was beginning to have a reaction, and diabetics sometimes need to have some sugar, to readjust. And he went to get some orange juice to counteract an insulin injection he was having. And he goes into the store outside of Charlotte, and he saw there was a long line. He looked at it, and he left right away. The police officer said, well, that's weird. Remember our case that we talked about, Terry stop, where a police officer saw three people acting weird? Well, this guy saw a guy come into a store, see a long line, see a cop potentially, gets nervous, leaves. Conner, the police officer, arrests Graham, suspecting him of robbery. So what happens is, about 1.5 miles from the store, there's an investigatory stop. And Barry told Conner that he was suffering from a sugar reaction, and Conner told
Barry and Graham to get out of the car and wait while he found out something. Officer returned to car to call for assistance. Graham got out of the car, turned around twice, sat down on the curb, and passed out. There was a good degree of confusion after that. A number of police officers arrived in response to Connor's request for backup. One of them rolled Graham over on the sidewalk and cuffed his hands, ignoring Barry's plea to get him some sugar. Another person said, well, I know what a diabetic is like, and this is not a diabetic. Unfortunately, apparently he didn't know because it was. When he got conscious, Graham asked the officer to check his wallet for his diabetic card that he carried, and another officer said shut up and refused, shoved him onto the hood. They then grabbed him and threw him headfirst into a police car. A friend of Graham's had by this point brought some orange juice to the car, but the officers wouldn't let him have it. And Officer Connor then received a report that Graham had done nothing wrong at the convenience store, and the officers drove him home and released him. Now, at some point, they broke his foot and cut his wrist and bruised his forehead and injured his shoulders. And Graham sued, claiming that this was excessive. And the standard then, Graham versus Connor standard, said, and this opinion is written by Rehnquist, is this an objectively reasonable behavior from the perspective of the police officer? Okay. The motive of the officer is not critical. The amount of force is. The severity of the potential crime, the threat, and the danger is important. All of these needs to be analyzed. The end result is, of course, there are limits on how you can behave when you're taking someone into custody. Now, this next slide I'm going to show you is the law of arrest in North Carolina. North Carolina law on arrest is found in the North Carolina General Statutes, Chapter 15A, subcategory or category section 401. And it creates two categories of arrest. It says you can arrest with warrant and you can arrest without warrant. It gives you definition how an arrest is made, and it limits the amount of force. This really is a central statute in North Carolina if you're going to look at it. So the police may arrest anyone for whom they have a warrant in their possession, and if you have jurisdiction. The police may arrest anyone if there's a warrant but they don't have it. However, they need to get it as soon as possible. In other words, it's great if they have the physical piece of paper in their hand, but if another officer has the warrant, the actual individual piece of paper, as soon as they can, they need to get that warrant. Now, what about arresting without warrant? The police can arrest you if you've committed a felony and they have probable cause to believe you committed that felony. They can arrest you for a misdemeanor if you're going to escape arrest, if you're not taken in, or if you are a danger to yourself or others. Generally, we really prefer having warrants for misdemeanors. How an arrest is made. The arrest is complete, this is North Carolina, when the person submits to the control of the officer who has indicated his intent to arrest, or when that person is taken into physical possession. If you're in the back of the squad car, in handcuffs, the arrest is complete. Police, of course, have to identify themselves as police, unless it's apparent they're wearing their uniform. They have to inform the person under arrest, and they have to reasonably inform them of the cause of the arrest unless it is evident. What kind of force can you use in North Carolina? The police may use general or non-deadly force if they're using it to prevent prevent escape, or to effect a lawful arrest. When can they use deadly force? If they're defending a third party or themselves from deadly force. If they're trying to effect the arrest of someone who has a deadly weapon or is an imminent threat of others going to shoot, kill, harm, or seriously injure them, or if they're trying to prevent the escape of a person that's in custody that's been convicted of a serious felony. Those are your limits. So the police they're not 007, they don't have a license to kill. All right, what about after arrest? Just got a couple more slides to go and one more case to look at. So when arrested for felonies, suspects are taken to the police station for further processing. When arrested for misdemeanors, usually you are then released. Now, what can happen afterwards, of course, is that you wind up for a felony. You're going to be held. For misdemeanor, usually you're going to be released in your own cognizance. Um, Now, your book at this point had a couple of cases. I didn't necessarily outline them. They had the case of Kahuna versus, I'm going to butcher this, uh, Minnetonka, which is a Minnesota case, and it's about a dog bite and hold policy, whether it's reasonable. And in that case, the court said it was. And then the other case I didn't really look at was the estate of Armstrong versus the village of Pinehurst. Um, and this is when Ronald Armstrong's estate sued Pinehurst um, because of excessive force during the execution of an involuntary commitment order. And I didn't go into that second one because I think it kind of muddies the water, an involuntary commitment order. But this next one I think is an interesting case, and sometimes is a bit of a shock, but I think it illustrates some points. And this is Atwater versus the city of Lago Vista. This came down in 2001, and this involves a woman, Gail Atwater. This was written by Souter, um, and it was joined by Rehnquist, Scalia, Kennedy, and Thomas. So Gail Atwater was pulled over for not having a seatbelt on, nor her kids, and she was driving home at 15 miles an hour from a soccer game. And this is Lago Vista. It's in Texas, actually. It's a suburb of Austin. And she was a full-time mother. Her husband was an emergency physician. It's a spring day. It's in the afternoon. Birds are chirping, everybody. And it's a violation of Texas Transportation Code. Her 4-year-old son, 6-year-old daughter not wearing their seatbelts. The police officer, a guy named Bart Turek, decided that he was going to arrest her. So he pulls her over. She's in a pickup truck, and she and her kids remain in. He approaches the driver's side. He apparently he's it has a bit of an attitude. The penalty's a fine, but he handcuffs her, and then he brings her into custody. Um, Tuck really, from at least the court, was pretty abusive, if you read the record. He accused her of not caring for her children, and he was pretty vocal. Now, he had stopped her before for allowing her son to ride in the front seat armrest, but the seatbelt was fashioned, so there was no citation there. And he told her, "You're going to jail." He demanded to see her driver's license, proof of insurance. She said they're in her purse and I don't have them. Turek ridiculed her, implied that she was a liar. Under Texas law, he could have just issued a citation. He instead handcuffed her, hands behind the back, put her in the squad car, took her to the police station. Um, and she went through, the kind of classic booking procedure: shoes off, glasses, empty your pockets, has her picture taken. She's then in a jail cell for about an hour before being taken in front of a magistrate. She pleads no contest. Um, they dismissed the charge without a license or proof of insurance because she had them. The youngest child has a few issues. Um, Basically, the police, in exercising discretion in their work, are protected against lawsuits on violations. Now, the dissenting opinion here, because this stop is upheld by the court. Um, this stop says it's okay. The dissenting opinion said it really is opening it up for grave abuse. The dissenting opinion is written by O'Connor. Um, the majority opinion said yes, it was humiliating, but it was brief, and she wasn't suffered a lot of harm. Certainly not as no more harmful than normal custodial arrest, um, and her fine. So the Court of Appeals judgment is affirmed. It's a good stop. And this is kind of a shock when we think about it. I think one of the reasons it's a shock is that usually when you're reading a criminal case, you're thinking, okay, this is a bad guy. This is a guy that committed a robbery, a rape, a murder. And we kind of flip this on its head, and what we have is a mother, which elicits our sympathy, a woman, which again typically elicits sympathy, a very minor crime, um, 50 miles an hour without a seatbelt, and kind of abusive behavior by the police. So, we're not going to, the court, I don't think, is going to defend, because they certainly put it in the record, how the cop behaved. But essentially, they said is, yes, it's bad. No, you can't sue about it. It's not bad enough that rises to the level of the lawsuit. Now, the dissenting opinion, was longer in many ways. It basically said that the indignity she suffered and the potential of grave abuse is serious enough that we probably should put some limits. I think it's an interesting case. I don't think these things are done. I do think that as we go forward, as the nature of the court, which is now even more conservative than it was in 2001, I wouldn't look for the court to say that arrests like this are in any way unconstitutional. Okay, well, that's about 50 minutes. I like to keep it between about 45 and 50 minutes. Uh, when we come back, we're going to pick up with Chapter 6, which is searching for evidence, the different searches. Other than that, you have a pleasant day. I will see you next time.